With respect to personal injury cases, if you divide them up into stages, we've talked about the first two stages. There's the gathering information phase, the so-called intake phase. Then there's the pre-suit stuff that we've been talking about, pre-suit investigation, and then the third phase is the settlement negotiations phase, and that is related to the first two. But what you're trying to do is determine whether or not your clients reached maximum medical improvement. That means they've gotten as good as they're going to get in terms of their improvement. They may have future medical issues. You need to determine what those are, determine what the medical bills are, what the lost wages are, have some sort of a handle on the pain and the suffering, and whether or not you're in a position to to send a settlement package to the insurance company. And sometimes a combination of insurance companies. You're going to want to know coverage limits. You're not going to want to settle a case cheap if you've got more coverage and injuries that exceed the amount of coverage. You want to make sure there's enough coverage there. If you're limited, that's all you can get, then you may have to consider whether or not you're going to want to settle, because it doesn't matter if you've got a judgment for something that's far in excess of coverage limits. So those are all things you're going to need to determine. But the maximum medical improvement part's significant because you want to determine that, because you don't want to settle a case too early, and obviously you don't want to settle it beyond the statute of limitations. That's something you're going to want to know very early on. If you don't file before the statute of limitations, generally speaking, you're out of luck. They say SOL, that means you're past the legal deadline, and there are a lot of policy reasons for that. So sometimes, and a lot of the time, quite frankly, cases settle before you even file a lawsuit. Lawyers often, if they're not having to actually file a lawsuit, will charge a third for the fee. That's typically what we do, third of the total recovery. Normally, if you have to file a lawsuit, it's 40%, and that's just standard because you're taking on risk as a lawyer. If you don't win, you don't get a settlement, you don't get paid at all. You usually get your costs as well. But you don't do that. You don't take cases unless you think you can get them appreciably more than they'd be able to get on their own. And that's sort of an ethics, your own morals about how you treat people, and wanting to make sure you put them in a good position, a significantly better position than before they hired you. Now, you can't guarantee that, but you want to try to do the best that you can. So a lot of the time, pre-suit stuff, you get a good demand letter together, you put the medical records, you get a statement from a doctor that says, yeah, this wreck caused this injury, this person was doing pretty well before, and it caused